Please join fast, everyone. Put me a message whether audio and video both are clear. This is a 30 marks sure shot exam questions marathon. Follow properly for the next 2.5 hours. That's it. Your 30 marks will be done. So please communicate with all your friends as well. I'll be sharing the link in all of our groups. Please join fast. Those who joined live, please give me a message whether audio and visual both are clear. Share with your friends as well. We'll start with the marathon. Before we start, in this particular marathon, we are going to cover guess questions from 3 10 marks chapters. Okay, how many? 3 10 marks chapters. Number 1, share capital. Number 2, general meetings. Number 3, accounts of company. These are the 3 chapters which are coming on an average for 10 marks in examination each chapter, not all the 3 together. I will show you the trend also before that, so you can really understand what is the importance and significance. Okay, see here, that trend till 2025 I have taken the trend of these chapters. Okay, have a look. When I talk about share capital, 9.48 marks, 10 marks. Management administration general meetings, 10.88, I will take 10 only. Accounts of company, 8.64, I will take 9. Here actually 10.88, I can take 11. So 11 plus 10, 21, 21 plus 9, 30. So 30 marks average it is coming in examination from these 3 chapters. So a fool only will leave these 3 chapters and go to exam hall. So let us not be a fool in that way. So let's cover these concepts clearly. Okay, with regard to the chapters like PEMA, LLP, already I made my revision videos and I kept in the YouTube channel. So just search with my name for that respective chapters, or else I will again share it. So you can just go and you can listen to them. So that's not a problem. Problem comes with the Companies Act mainly. So that's why we are focusing on these three areas now. One is a share capital, another one is a debentures. I mean, share capital and debentures is one single chapter. And next one will be, so share capital and debentures will be one topic. And second one will be general meetings. And third one will be accounts of company. All the three chapters will come for 10 marks on an average. This is a 30 marks marathon. Clear everyone? I'll wait for another 5 minutes and I will start. For that, please inform all your friends to join the live, complete along with me such that you need not put any burden of listening to these or reading these contents once again. So on par with the exams, we are going to have this marathon. Before everyone join, I will just write down the expected sections from the three chapters. Share capital, general meetings, accounts. Share capital chapter, section 43 rules, differential voting. Section number 48. Section number 55. One second. Section number, okay. Section number 55. Section number 62. Section number 63. 67. 68 and related sections and a buyback related. These are all the expected questions for this examination. Okay, 43, 48, 55, 62, 63, 67, 68. Okay, along with that, I can add one more sweat equity shares concept also we can add. So sweat equity shares also can be added to this. That one more section we will cover. Okay, general meetings like expected questions will be section number, if you can observe clearly, the most important sections in general meeting chapter, as we already know, one is section number 101. In that, we are more concerned about notice by way of email. Next one, section number 102, subsection number 1 is more important than 2. Next one, section number 103. Section 105, the most important section, which is relating to proxy. Question is expected. Next one, section number 108, electronic voting. Next one, section number 111, circulation of members resolution. Next one, special notice 115, 118 minutes, 118 and 119, both are minutes. That's it. These are all the expected concepts in general meetings area. Okay. Accounts of company, expected contents are as follows. Section 128, section number 130, section number 131, section number 134, 134 signing is more important, only that content, not everything. 135, the most important of all, CSR. 136, 137. Accounts of company chapter important because they are asking 2 MCQs and 2 descriptive questions in exam for 10 marks. They are asking all 3 marks questions in that chapter. So we need to prepare well. First, note this down before we start. Can we begin? Those in live, please give a reply. Can we start? Okay. So the revision starts with the chapter share capital and debentures. As I already said, it's a 10 marks chapter. You can expect 2 to 3 questions in exam from the chapter share capital and debentures. And the guest questions for this attempt are section number 43 with the rules, which is talking about differential voting rights. 48 will be talking about variation of shareholders' rights. 55 will be talking about redemption of preference shares. 62 will be talking about right shares and ESOPs and conversion cases. 63 will be talking about bonus issue. 67 will be talking about the purchase of company of its own shares. 68 and related sections will be talking about buyback. This is all one set of sections. Next, 101 will be talking about, when we come to the chapter, at the beginning itself, we will discuss about what are all the section contents. First, let us start with the expected questions and try to cover them. So we are going to start first with section number 43, which will be talking about differential voting rights. See here. First point number 1. Differential voting rights is a concept where generally in terms of equity shares will have two important rights. Number 1, every share will have one vote. Second one, every share will get a dividend. Okay. So whenever company declares a dividend on a per share basis, every shareholder should receive the dividend on a per share. However, whenever company issues a differential voting right shares, in that case, there will be upside and downside. Let me first explain you what is upside that can happen and downside that can fall. So number 1, whenever we are issuing a differential voting right shares, the first thing that happens is, normally what is the scenario? Every share will have a voting right. Every share will give a dividend on a proportionate basis. However, if the differential voting shares are there, sometimes they may give higher voting rights. Compensatingly, they will reduce the dividend. Or they will give lower voting rights. Compensatingly, they will give you higher dividend. This concept of either increasing voting and decreasing dividend, or decreasing voting rate and increasing dividend, when the shares are issued, we call them shares issued on a differential voting right. Is the first concept that we need to understand. Okay, but try to understand clearly. Differential voting rights means normally what the company has to do, on a share we have to give dividend, on a share we have to give voting right. But you are deviating from the general principles and you are issuing the shares. Therefore, conditions are very strict and stringent in terms of the following. A company which wanted to issue DVR should have 3 different parameters to be checked. Parameter number 1, it should be compliance parameter. Simply the approvals, which means board approval, shareholders approval, like that. And the second thing we'll be talking about financial compliance. Simply to understand, what does it mean? Okay, what do you mean by financial compliance? Financial compliance represents the concept relating to making the payment to the creditors properly, making the payment to the debts properly, making payment of dividend properly. These all we are going to check in the financial compliances. Next one will be legal compliance. Means you should not be convicted under FEMA Act, you should not be convicted under RBI, you should not be convicted under SEBI, you should not be convicted under SCRA. Like that, there are so many legal compliances that we need to comply with. Clear, everyone? So this is what we need to understand. So first thing is approval, second thing is financials, third one is legal. If you remember these 3 points, making a mistake in examination will be almost reduced to 0 level. Okay. So let us start. So compliance approvals, let us see what are all the approvals that are required. Number one, whenever DVR question comes in examination, you have to write 8 points totally. Point by point, I will mark. Please listen carefully. Number one, articles of association should permit. Articles shall authorize the issue of DR shares. Shares with the DR means shares with the differential rights. If articles is silent, alter the AO. Means what? If articles of association of a company is silent, that does not mean you are having implied authority to go for DVR issue. No, you have to alter the articles, insert DVR into it, then go for issue of DVR shares. Next one, articles permission over. Second one, shareholders has to give permission. Normally, shareholders by passing ordinary resolution in general meeting is required. However, in a listed company, shareholders ordinary resolution will be passed, but not in a general meeting, but by way of a postal ballot. So normal capacity companies are there other than listed. In such case, ordinary resolution. If it is listed company, ordinary A, but we should not pass it through general meeting. We should pass it through postal ballot. Important MCQ. Next, sir, DVR shares la what will happen? High voting, less dividend. Less dividend, high voting. Or less voting, higher dividend. Like this it can happen. Na? Therefore, can a company have totally DVR shares? No. DVR shares, a percentage of DVR voting power cannot exceed 74% of the total voting power. Means if the total voting power is 100%, okay, DVR voting power cannot go beyond 74%, and 26% should be reserved to non-DVR shares. Next, voting power of DVR can be either in multiples or in fraction. Just now I told you, sometimes I will give higher voting for lesser dividend. Then voting rate will be in multiples. Lesser dividend, okay, or lesser voting, higher dividend. Then voting rate will be in fraction. Normally 1 share, 1 vote. Or I will tell 5 shares ki 1 vote. This is fractional voting. I will tell normally 1 share, 1 vote. I will tell 1 share ki 5 votes. This is multiple of voting. Everybody who are listening to the live up to here, everyone got a clarity, yeah? Because I am going to cover all exam points also in the charts itself. So you should say yes, 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 consistently. Participate in the meet completely throughout the end. You will complete along with me. Everyone say yes. Next one. So we completed articles permission and percentage of DVR and permit of shareholders. So articles permission over, shareholders permission over, and third one will be maximum limit. So we completed AOA, we completed shareholders, we completed percentage. The basic approval set. Next, financial compliances. Financial compliances. In these two points will be there. One, monetary compliances. One, monetary compliances. Second one will be financials filing compliances. Okay. Number one is financial means directly payment loan default is there. Second one, payment loan default is not there, but the financials has to be filed with the department ROC. That they did not do. So what we are going to do is we have to understand what are all these financial defaults that can occur. Number one, please participate. No filing default. No default in filing. No default in filing what? If default exists in any one out of 6 filings, company cannot go for DVR. Sir, what is a 6 filing? Financial statements and annual returns in 3 financial years preceding the financial year in which a DVR issue is being made. Let us understand and break down what is the meaning of this particular point. Examiner, one question also came on this. Please attentively listen to the discussion. Point number 1. No filing default. You did not commit a filing. You did not commit a default in filing. Default in filing is not committed in respect of what? Financial statement and annual return. Listen carefully to the meaning now. Interpretation of statutes, you will read one word. Understanding the meaning of the word and. What do you mean by and? And represents a conjunction. Means it brings two things into one single set by adding a word called as a and in the provisions. And always represents a conjunctive discussion, which means A and B means both should be satisfied. And what is the discussion we are going to make? See here. No default in financial statement and annual returns, they said. Default should not be there in both of them. Means if any one default happens now, you cannot issue DVR shares, disqualified. So that's why what I'm going to tell is, if you wanted to issue DVR, you should not get defaulted in any of these. Okay, you should not get defaulted in any of these. So financial statement and annual returns, there should not be any kind of default. Any one default, that too for how many years? 3 years. 3 years financials, 3 years annual returns. Means how many totally? 6 filings will be there. In this 6 filings, any one filing, if you have done any kind of mistake, that's all gone. You cannot go for DVR. Next one. No subsisting default, whether active subsisting default or ongoing subsisting default. Simply active or ongoing. Payment of equity dividend, redemption of preference shares, redemption of debentures, interest on deposits, interest on debentures, repayment of deposits. Repayment of deposits. Easiest way of understanding this. First one, come to the debts. Interest on debentures, interest on deposits, redemption of debentures, repayment of deposits. Debts ki 4. Deposit interest, debenture interest. Deposit repayment, debenture redemption. In this, if there is any kind of default, over. Next, debt related another instrument, preference share. Redemption of preference shares if you do any mistake, then gone. Next, payment of equity dividend. Declared equity dividend but did not pay. So in that case also, you cannot go for DVR issue. Okay. Next, but try to understand. That should be a subsisting default. What do you mean by subsisting default? 4 years back, company declared preference dividend, or company have to redeem the preference shares. It did not redeem. But after 2 months, they redeem. Now today, on the date on which you wanted to go for DVR, there is no default. So no problem. So subsisting default, we need to consider this set. Next one. Special defaults. It is important for exam. Please listen carefully. What is this special default? No default in dividend on preference shares. Redemption of preference shares comes under subsisting. Dividend on preference shares comes under special default category. Market important. So dividend on preference share. Principal or interest payment to public financial institution, state financial institution, or scheduled bank, whether commercial or private cooperative banks, everything is covered. Okay, commercial and private cooperative banks are not covered by this particular thing. Only scheduled banks are covered. So point number 1, dividend on preference shares, special default category. Sir, what is a special default? That's why, see, if the above defaults are rectified, then DVR issue may be made after 5 years from the end of financial year in which the default was made good. I have to discuss on this. Exam questions also came. Let us try to understand what is the meaning. See, I have to pay dividend on preference share as on 31/3/2022. 31/3/2022. I did not pay. Let us see two situations. Preference shares has to be redeemed on 31/3/22. Preference dividend has to be paid on 31/3/22. And we have to pay dividend and redeem them. This I have done due date. I did not do. This also I did not do on due date. But I have done this on 30th June 23. This also I have done on 30th June 23. I wanted to issue DVR shares in the year 2026. I can go. But you cannot go in this case, because in this case, you have to see this condition. If the above defaults are rectified, then DVR issue may be made after 5 years from the end of financial year in which default was made good. When default was made good? 36 to 23. Which financial year it will fall? 23-24. When 23-24 will get completed? 31-3-24. From this 5 years. Okay, simply to understand, you have to take the following financial years. 1-4-24 onwards you should start. Okay, 24, 25, 26, 27, 28. At that time ending, I have to go for DVR issue. Everybody please answer. Did you all understand the discussion up to here clearly? Everyone. Tomorrow you are having exam. Please don't waste time in watching TV. Please listen to the concept. Everyone. Clear? Next. So, what are all the defaults that are covered in this? Let us see. Dividend on preference shares, principal or interest repayment on PFI, SFI and scheduled banks, commercial banks and private banks are not covered. Employee statutory dues, PF, etc. Next one, amount credited to IEPF default happened. In this case, the default, even though you rectify for a period of 5 years from the end of the financial year in which the default was rectified, for 5 years you cannot go for DVR. Next, last one is legal compliances. Legal compliances, no penalty on specified offenses. You should have committed offense. Committed offense either under RBI Act, SEBI, SCRA or FEMA. Okay, and it is an offense, not a civil case. It's a crime. You committed a criminal offense under these acts and you are penalized. Okay, if you get penalized in any of the last 3 years, you cannot, that company cannot go for DVR. Means DVR is a commitment. I should believe you. Filing you don't do properly, bank payments you don't do properly, employees dues you don't do properly. How can I believe that you will really make the higher dividend and lesser voting, or higher voting and lesser dividend? How can I believe? Other logic behind this particular section. With this, we completed our first guest question in this chapter, share capital, differential voting right. 1 minute time for you to read. Once you complete, we will go into the next one. 43 completed. We will go directly to section number 48. First of all, everyone, please tell me from where all of you are participating. Please put a message there. From which place you are participating in this particular meet. Please put a message. And second very important thing, whether you understood this or not also, you please put a message. We are going with the others. One, you completed this now, revise everything now itself. Because in this 2.5 hours, we are going to complete this 30 marks marathon. Such that this will be giving a definite value addition for the tomorrow's exam. So please complete section number 43. Then we'll go to section number 48. 1 minute time for you to read. Complete it fast. Have you all completed? So let us begin with the next question. Section number 48. So the next guest question is variation in shareholders' rights. See, let me explain what is the concept of variation in shareholders' right very fast. Okay, and the share capital chapter we are giving 1 hour time. 1 hour we have to complete this 10 mark segment. So number one, variation in shareholders' rights is something similar to DVR. Company issued shares as a normal shares. Later they are going for a conversion into DVR path. Simply to understand, DVR shares are issued from the very beginning as, okay, from the beginning they are issuing as a DVR shares. But now what they are doing, they are issuing as a normal share. Later they wanted to vary the rights. Which right? Either a dividend right or voting right. They wanted to change. This is a much serious issue than section number 43, read with the rules. So how to tackle this? Let us try to understand and complete section number 48. Point number 1, applicability. Section applies to all the companies, whether public or private. Means any company can go for variation. Prerequisites for variation means what are the important things? Number 1, MOA or AOA should first give us a permission to go for variation shareholders' rights. If you don't write any one of these points, your marks will be gone. So listen to the point clearly. Section applies to all the companies, whether public or private. Number 2, conditions for applicability. May either MOA or AOA should authorize. Number 1. Next one. See, two things we need to understand. For example, prerequisites are either this or this. MOA should authorize me. AOA should authorize me. Either any one of these or both also very good. So either MOA or AOA should first give us a permission to go for DVR issue. Number 1, understood. Number 2 is much important. If MOA, AOA do not permit you, DVR what we read, AOA should permit. If AOA do not permit, you should go for alteration of AOA. But variation, that problem is not there. Why? Already the shares are issued. Na? Therefore, you do one thing. Check whether MOA is giving you a power. No, sir. Check whether AOA is giving you a power. No, sir. At least check when the shares are issued, shares will be issued using a contract. In the contract, is there anything written clearly that variation is not permitted? No, sir, nothing is written. Then you can go for variation. Clear? And how they can ask a question in exam? See here. MOA, AOA, terms of issue of shares. Next, variation. See here. How they can twist the question in exam. A difficult question can come like this. First, MOA permitted, AOA did not, or MOA permitted, AOA permitted, terms of issue permitted. You can go for variation. MOA permitted, AOA did not permit, terms of issue permitted. You can go for variation. Okay. MOA did not permit, AOA permitted, terms of issue permitted. You can go for variation. Next, MOA did not permit, AOA also did not permit, terms of issue permitted. Then you can go for variation. MOA did not permit, AOA did not permit, terms of issue also prohibited. Then you cannot go. MOA prohibited, AOA prohibited, terms of issue is silent. Then you can go for variation. So terms of issue need not be specific. Even if it is silent, you can go. So when you cannot go for conversion or variation, if it is not prohibited by terms, means what? If it is silent also, no problem, you can go. But if it prohibited by terms of issue clearly, then you cannot go unless and until MOA, AOA permits it. Okay. First of all, everyone please give a reply. Did you all understand this table? Have you all understand this table clearly? MOA, AOA and the terms of issue and going for a variation. Those who do not understand, listen again. Go back and listen to the content. Okay. Next. Basic condition. So we completed MOA authorization or terms of issue not prohibition. Next, basic condition. Company should have different class of shares. So when company is having only one class of shares, you cannot convert. Company should have different class. When I say different class, how the classes are different from each other in a company on the basis of par value, on the basis of paid up value. Means 5 rupee face value, 10 rupee face value is not of the same class, even though both are fully paid up. 10 rupee share and 10 rupee share is not a same class if paid up value is different. Paid up value and par value both should be same. In that case only we will call it as shares falling under same class. Like the different classes of shares should be there in the company. So on one class you are going for variation. Okay. and company has only one class, section 48 does not apply. So company should have different classes of shares first. On one class, you are going for variation. Okay, next, approvals. Approval of shareholders. Option 1, you can have two types of approval. My company is a small company. Small company definition of small company. The normal small company means having only 150, 70 shareholders are there. Very little amount, or 10, 15 shareholders are there. If it is a private limited company, then what will happen? Conducting a meeting is unnecessary waste of time and money. At that time, take the consent of shareholders holding not less than 3/4 of the value of shareholding. This is very important because you need not take the permission of 3/4 of shareholders. See how many shareholders are there in a company. Sir, 50 are there. In that 50, 10 shareholders are holding 80% of the share capital. That's all. If those 10 shareholders give the permission, even though the balance 40% do not give a permission, you can go for variation because substantial holders are okay with the variation. So obtain the consent of shareholders holding not less than 3/4 in shareholding. Second option. Sir, going to each and every person is very difficult because the company shares are widely scattered. Company shares are widely scattered across the globe. It's a multi-dominant company which is having branches across the world. Shareholders are there across the globe. It will be very difficult for taking a one-on-one permission. Therefore, in that case, conduct a general meeting, pass a special resolution in a separate meeting. What do you mean by separate meeting? You should give an agenda for variation separately. You should conduct a meeting and take the approval. Normal meetings, one of the agenda item cannot be the variation. This question can be tested linking with general meetings chapter. So please take reasonable care. I repeat one last time. Variation in shareholders' right is one of the most important issue in a company. You cannot mix this with other agenda items in a general meeting. You should make it as a specific agenda. Next one. Approval of other class. There are two different classes of shareholders. Now problem will start. My par value is 5 rupee. Your par value is 10 rupee. You will get one share, one vote. You will get one share, one vote. Now my rights are getting varied. 5 rupee par. They said I will give lesser dividend, but I will give 2 times the voting right. Now what will happen? A 10 rupee shareholder will get one vote. A 5 rupee shareholder will get 2 votes, which will be on par with the same person. I will give you an example. See here. Normally what happens in a company, two classes are there, class 1 and class 2. They are asking questions like this only in exam. They are not repeating the past questions. So please be very careful. Okay, last 2 days back, CA final AFM paper, you should see people literally cried in exam hall. So please don't be in a wrong impression that they are going to ask questions from the past question banks, etc. It is only for understanding the trend and patterns how the question will come. But please be careful, listen carefully to the point. I repeat one more time. There are two classes of shareholders. One is a 10 rupee par, one is a 5 rupee par. Both will attend meeting. How voting will be given? If you give one vote for him, na slip parta he will hit. Why? Problem is a 10 rupee person will get one vote, 5 rupee person also will get one vote, means everyone will buy these shares only. Therefore, in order to have a commensurate voting system, what Companies Act has done, for 10 rupee share you are giving one vote. For these people, we will give one vote for 2 shares held. Okay, simply to tell how to understand, every 2 shares ki one vote will be given. This is normal shares. General meeting normally this will be happening. Now what happened? These shareholders' rights are getting varied, where we said we will give you lesser dividend. We will give you voting right. What do you mean by voting right? Normally you will get 5 rupee share, means how many votes you will get? Half vote only you will get. And you should hold 2 shares to get one vote. Now we will say 1 share ke 1 vote we will give. Then these people will get hurt or not? In that case, you take the permission of 3/4 of the shareholders of other class. Now you should understand 3/4 of the shareholders of the other class. Shareholding illa, shareholders head count. If there are 1,750 shareholders has to give the approval. I don't know how you will remember. You have to remember. That's why this section is extremely important in nature. And final, application to NCLT. By whom? Shareholders holding not less than 10% of the shares, or shareholders holding not less than 10% of the shares and who participated in special resolution. Okay. Shareholders holding not less than 10% of shares, or shareholders holding not less than 10% of the shares and who participated in special resolution. These people, these shareholders, can go to NCLT for cancellation of variation. How many days? Within 21 days after consent or special resolution. If they give consent directly, na, from that day 21 days. Special resolution passed, na, from the meeting 21 days. They can go for NCLT for an appeal. Decision of NCLT will be binding, means NCLATQ cannot go. Decision given by NCLT will become final. ROC, NCLT order shall be filed with ROC within 30 days of order. Okay. So sum up everything. Variation can be done by public, private, everyone. Second one, MOA, AOA authorization is required. If that is not there, at least it should not be prohibited by the terms of issue. First 2 points over. First, approval of shareholders. Two types of approval. Number one, either obtain the approval of shareholders holding not less than 3/4 of the shares. Okay, 3/4 of the shareholding. Or second one, if you don't want, pass a special resolution. Pass a special resolution. If your variation is affecting other class, then 3/4 of the shareholders of that other class also permission has to be taken. If anyone is hurt by that, not less than 10% of the shareholding, if they have, they can go to NCLT asking for cancellation of variation, though it is approved by special resolution. Section number 48, variation is completed. Everyone, please give a reply. Did you all understand this section clearly? Second expected question is also completed. So wait a minute. We completed 43, we completed 48. Next, we are going into section number 55. Before that, please complete through the chart section number 48. Once for all, this will be your last time seeing section number 48 before the exams. I'm making it full screen. Please read, complete it fast. We'll go to section number 55. One person. Everyone completed? Can we continue? Okay. Next. So we completed section number 43 and section number 48 expected question. Now we are going into sweat equity shares. Okay. Let us move on to sweat equity shares. Actually, sweat equity shares is also there in our expected question. Two-minute discussion. Yes, sweat equity shares. Much time I will not take. See, one page. Okay. If you read this one full page, that's it. Your work is done with regard to sweat equity shares. Let's have a discussion now. See, concept is sweat equity shares. First, I will give you overall idea behind the sweat equity shares concept. Then we'll start and complete. Time given is 7 minutes for this section. Okay, let's begin. Point number 1. What is the sweat equity shares? Sweat equity shares are issued by the company to the directors and employees of a company for creating know-how, and value additions within the company. Simply to understand, for giving some benefit to the company, value addition to the company, companies will issue sweat equity shares to its employees and directors. So directors and employees of a company will be given with sweat equity shares within a particular company. For giving value addition, their intellectual property rights, know-how, etc., companies will issue shares at a discounted price or almost with no consideration. This is called as a sweat equity share. Normally, issue of shares at a discount is prohibited, but this is an exception for that. So, sweat equity shares is an exception for issue of shares at a discounted price, because here we will be giving at a discount. Okay, next. Now, question number 1. Sir, what are the conditions for issue of sweat equity shares? See, there are 4 very, very important conditions you need to quote in exam. Number 1, shares of that class are already issued. Means sweat equity shares, whatever you issue should not be new class. It should be of the same class. Next one, it should be authorized by special resolution. Authorized by special resolution. And moreover, once you pass a special resolution, within 12 months of passing that special resolution, you have to complete sweat equity issue. So validity is only for 12 months. Next one, in the special resolution you pass, it's an ordinary business or special business. General meeting chapter we already read there are 4 ordinary business: accounts, dividends, directors, auditors. These are 4 ordinary business. Other than this 4, everything is a deemed special. So obviously sweat equity shares comes under special. Special business require explanatory statement. In that explanatory statement, you have to explain about, okay, number of shares you are going to issue, what is the market price of those shares you are giving free of cost to directors, and if there is any consideration that they are giving in return, clearly you have to mention. Next one, shares are to be issued as per, if it is a listed company, as per SEBI regulations, any other company as per Rule 8 of the company's rules. Next, sir, you are issuing sweat equity shares. We are getting any extra voting rights? As a sweat equity share, say I am giving free of cost. Extra voting rights or extra dividend we will not pay on that. Therefore, rights, limitations, restrictions shall apply as to sweat equity shares. Mean whatever conditions are applied for normal equity will be applicable equally for sweat equity shares also. Next one. Next question will be limit on issue of sweat equity shares and lock-in. Sir, what do you mean by that? Sir, can a company have completely sweat equity shares? See, maximum sweat equity shares that can be issued in a year is a year of 15% of existing paid up equity share capital, or shares of issue value of rupees 5 crore, whichever is higher of 15% of the existing paid up equity capital. Okay, for example, if the paid up equity capital now is, say example, 100 crore into 15%, 15 crore or 5 crores, whichever is higher, to that extent it will be allowed. But there is another condition attached to this. Issue of sweat equity shares, including the previous issues, shall not exceed 25% of the paid up equity capital. Means already sweat equity shares are issued 4-5 years back. Now again I am issuing. all put together should not be more than 25% of the paid up equity capital at any time. Okay, there is an exception. Startup, which is a private company startup, can issue shares up to 50% of paid up capital for up to 10 years from the date of incorporation. For encouragement purposes, for creating know-how and value addition, we can give up to 50%. Which case? Startup private company case. Lock-in. Once you issue sweat equity shares, people will take. Immediately they can't sell. Lock-in period will be 3 years from the date of allotment. Other provisions of sweat equity shares. Whenever you are issuing sweat equity shares, you have to match the value addition given by the employee and the shares you are issuing. Common sense example. For example, you are an employee in a company. Company said that you are giving a lot of value addition to the company. Because of that, we are issuing sweat equity shares. Now the question is, what value addition he has given? He has given a lot of HR resources, a lot of production process, lot of knowledge he has given to company. Sorry. How can you tell that these many shares will equate to the knowledge he has given? For that, some valuation has to be done or not. That's why sweat equity shares valued at fair price. Valued at fair price. So fair value of the shares they will calculate. Gordon model, P not equal to D1 by KE minus G. Using that, first they will value the share price. That much value whether this fellow has given or not. Now they will value the intangible asset. See, knowledge is an intangible asset. Idea is an intangible asset. Value addition is an intangible asset. So what is the benefit company is getting? How many shares company is giving? Whether both are matching or not, valuation has to be done. Next, treatment in the books. If shares are issued for non-cash consideration, means what? For your knowledge given, we are giving shares consideration other than for cash. Okay, then depreciable or amortizable asset carried to balance sheet, otherwise recorded as an expense. Okay, these are all the main things that you need to understand. But one point, company has to maintain a register of sweat equity shares in form SH3 at the registered office. Okay, this is all about the main concept of sweat equity shares from the exam point of view. Read the chart properly before we go into next section. Read it. That's it. Exactly 7 minutes we completed this answer. Read sweat equity shares concept clearly. Have you completed? Can we continue, everyone? Reply. Next one. Let us go into section number 55. Let us go into what? Section number 55. Another expected question for the exam, section number 55. See, what is this section? This is an expected question for this exam at a higher level. If you listen, okay. If you don't listen, also very much okay. Okay. So let us begin. Issue of preference shares and redemption of preference shares. Issue of preference shares and redemption of preference shares. Let us try to understand what are the conditions for issue of preference shares and redemption of preference shares. Number one, issue of preference shares. Okay. Issue of preference shares. Conditions to issue redeemable preference shares by a company limited by shares. First one, authorized by AOA. Authorized by AOA. And next, special resolution is passed. So point number one, issue of preference shares should be authorized by articles and you have to pass a special resolution in a general meeting. This is one important point that we need to note. Next one, what is the tenure of a preference shares which are redeemable? Okay. See here. So what is the time limit for issue of redeemable preference shares? What should be the tenure? Redeemable preference shares should be redeemed within a period of 20 years from the date of issue. However, and then normally if you wanted to issue preference shares, AOA authorization is must. Special resolution has to be passed and the tenure of the preference shares should not exceed 20 years. However, in case the preference shares are issued by infrastructure companies or infrastructure project related companies, that company may issue shares for more than 20 years but not more than 30 years. However, normally the age of preference shares should not be more than 20 years, 0 to 20. But if you want to issue extra 10 years till 30 years, you can issue. However, from 21st year onwards, you should start redeeming at least 10% of the value every year, such that, for example, I raised 100 crores money today, redeemable after 20 years, but I wanted to redeem after 30 years. You can do, but entire 100 crores you cannot redeem at the end of 30 years. That's not possible. What you need to do is that 100 crore you divide it into 10 parts. 20 to 30 between you should divide. And every year you should redeem 10 crore. This part redemption you have to do after 20 years between 30th year. Okay. So redeemable within 20 years from the date of issue. For infrastructure projects, company may issue shares for more than 20 but not exceeding 30, where company redeems at least 10% of the shares annually from 21st year. Next, no subsisting default. In subsisting default means existing default should not be there in redemption of preference shares or payment of dividend on preference shares. Okay, so in the payment of dividend of preference shares or in the redemption of preference shares, there should not be a default. Next, if company wanted to issue the shares on recognized stock exchange, SEBI regulations also they have to participate. This is one point. Now what we completed, issue of preference shares over. To sum up everything in just 1 minute, preference shares issue is not mandatory in a company. Equity is mandatory. Number one. Point number two, preference shares issue require authorization of AOA. Number three, shareholders by passing a special resolution in a general meeting. Number four, tenure of preference shares should not go beyond 20 years. Infrastructure companies can go beyond 20 years but not exceeding 30, but a part redemption must be done after 21st year. Next one, there should not be a subsisting default in redemption of preference shares or payment of dividend on redeemable preference shares. And finally, if you are listed company, you should also obtain the approval of SEBI. Next, redemption of preference shares, the most important content in this section. Than issue, redemption is more important. Okay, redemption is more important than issue. Let us see. Preference shares shall be redeemed out of. See, very important thing is, what are the sources out of which you are going to redeem the preference shares? Preference shares can be redeemed out of profits of a company. Okay, which would be otherwise available for dividend, means free reserves only. Okay, free reserves and P&L account credit balance only you can use. Simply to understand, you cannot use any other fund other than these two for redeeming the preference shares. So preference shares shall be redeemed out of profits of the company available for dividend and a free reserves. And second one, fresh issue of shares means what? Issue new preference shares, get the money and redeem the old one, or issue new equity shares, get the money and redeem the old one. Next, If the shares are redeemed, just 2 minutes, you have to listen. Okay. If the shares are redeemed out of profits of the company, same like a buyback. Whenever company go for a buyback, you should create an account called as a CRR. CRR means Capital Redemption Reserve Account. What is a CRR account? Whenever preference shares are redeemed or whenever the equity shares are bought back out of the profits of the company, an amount equal to nominal value of the preference shares redeemed shall be transferred to an account called as a CRR account. I'm writing here. Please see here clearly. Important question for the exam. Preference shares can be redeemed out of two sources: profit source, new issue source. New issue source ki this rule does not apply. If the preference shares are redeemed out of profits of the company, then amount equal to nominal value of preference shares redeemed shall be transferred to an account called as CRR account. CRR account should be used only for issue of fully paid up bonus shares. So, source of premium payable at redemption of preference shares. Sir, preference shares must be redeemed out of profits or new issue, you said. I wanted to redeem preference shares at a premium price. For example, par value is 100. I wanted to redeem it 110. 100 rupees I will use profits. But what about the extra 10 rupees? From where I should pay the 10? That's why see here. If company wanted to redeem the preference shares at a premium, company wanted to redeem the preference shares at a premium, then if company follows section 133 under Ind AS, okay, then out of the profits of the company only that extra also will be paid. Otherwise, out of the profits or even out of securities premium. Means if you are following section 133 of Companies Act, then only out of profits you should pay that extra 10 also. But if you are following other than section 133 normal accounting standard, then you can pay either out of profits or even out of securities premium, because security premium is not a profit, it's a capital profit. Okay. Next, whenever you wanted to redeem any preference shares, it should be fully paid a preference share. Last and final discussion on this section number 55. If company is unable to redeem the preference shares, means failure to repay or pay dividend, etc., then to the holders of such shares, after obtaining the consent of 3/4 of the value of such shares and NCLT approval, can issue new shares. Simply to understand, whenever the company is unable to repay the preference shares, redeem, or paying the dividend on that preference shares, they can issue new preference shares. The moment the new preference shares are issued, old preference shares are deemed to have been redeemed. Okay, this is the point. Please read the preference shares issue and redemption for 2 minutes. We will be going into next one. And moreover, as per our target, what are the sections that we have completed? Let us stick here. We completed 43, 48, 55, 54. Now our target is 62, 63, 67 and 68. 67, 68 we will discuss as a set. First thing we need to complete 62 and 63. Okay. Read this document properly. 2 minutes time for you. Complete now itself. Don't postpone. Complete it now. Completed reading? Have you all completed? If you are done, please tell me. I will go to the next section. Okay. Completed, everyone? Next one. Next one is section number 62. See, section number 62, there are three parts: rights issue, ESOPs, and conversion cases. Rights issue, ESOPs, and conversion cases. Okay. See here. Further issue of shares. Rights issue. First one. Rights issue. Let me first explain you the whole idea and then we will read. Rights issue is made by the companies which are going for further issue of shares. Means whenever the companies are going for further issue of shares, they will not directly go to the public and issue. First, they will give a chance for the existing shareholders of the company to subscribe. That concept is called as the rights offer. Okay. Rights has two segments. Number one, offer letter. Number two, the shares. Rights offer letter will be first sent to all the registered shareholders of a company, and they will ask them to accept or reject or even renounce. Renouncing is a default option given to the shareholders of a company, and if company articles like clearly it is said that renunciation is not there, then only it will not be there. And in simple sense, how to understand? Renunciation is a default right given to the company unless articles prohibit it. If you do not understand my statement, go back and listen one more time. I will not be going to repeat again. So the point is, whenever companies are going for any kind of rights offer letter will be given, then rights issue will be made. What should be the time gap that will be between that rights offer and rights issue is what we are going to discuss now, and how this procedure will be there. Let's see. Point number one, it is applicable for both public and private company. Point number one completed. And it will be for increasing subscribed capital. Sir, why they are using the word subscribed capital? Listen, answer is very clear. There are 5 stages of capital. Number one, authorized. Number two, issued. Number three, subscribed. Number four, paid up. Number four, called up. Number five, paid up. Bonus issue will directly increase the paid up, because in bonus there is no authorized capital, there is no issue, there is no subscription, there is no calling. Directly we are going to add to the paid up. So bonus shares will add to the paid up capital, but rights is not like that. Rights has to be subscribed. Therefore rights require a subscription. So subscribed capital increase will affect the rights offer. This is how we need to interpret the provisions. I'm again retelling the same thing. Reading is different, interpretation is different. Law requires interpretation, not your bloody reading. Reading everyone will do. So you should interpret the terms in a proper way. When they use the word subscribed capital, you should understand the meaning of that word. Why they use the word subscribed capital? is the reason. Next, how the shares are issued. Okay, shares are issued in proportion to paid up value. Sir, what do you mean by that? In a ratio they will give 1:1, 2:1, 3:2, like that. In a ratio they will give. Next one, procedure involved, important. First procedure, rights issue is made to the existing shareholders. Very good. What will be made? Directly issue, offer will be made. What are the three rights that they have? Accept, decline, renounce. Renounce will be given by default. Okay, here renouncing is a right given by default unless it is prohibited by AOA. If any offer is declined, board of directors will take such decision which is not disadvantageous to shareholders. Offer letter will be given. A rights offer letter should contain number of shares offered, time limit, and fact that there is an option to renounce. Or else how the public will know? You are a CA student, I am a CA, I know that there is a chance of renunciation, but public also should know or not. So in the offer letter, whenever you send, three things you should send: number of shares you can purchase, time limit within which you should accept, decline or renounce, and the fact that there is an option to renounce. Next, how can sir, next one, non-acceptance within the time. Sir, time was given. Time was given. I did not accept, I did not reject, I said silent. Then it is assumed that you are declination. Okay. Sir, offer letter, how to send? Email, register post, speed post, courier, electronic mode, or any other mode which leaves a proof of delivery. Next one. Sir, what is the time limit within which I should accept, renounce or reject? Minimum 7 days, maximum 30 days. Minimum 7 days as per the rules, maximum 30 days. That's it. This is rights offer. Section 62, the segment 1 completed. Rights. Segment number 2, employee stock options. Say employee stock options. This is segment 2. First one, what is an employee stock option? It is an option given by whom? Company. Given to whom? Directors, officers and employees. Okay, DOE, whenever I write director, officer, employee, they are giving to DOE. Okay. Sir, ESOPs means what? Employee stock options. Sweat equity shares will be given free of cost or consideration other than cost or at a deep discount. Okay, discount means discount on par value. But when it comes to the concept of ESOPs, they will not give it a discount. They will give lesser than market price. That's all. Not lesser than par value. Clear, everyone? So ESOPs is an option given to employee. Given to employee. By whom? By the company. Sir, employee means whom? Directors, officers, employees. Okay, sir, can X Limited is their holding. So I will tell like this. See, A Limited, B Limited, X Limited. A holding, X subsidiary, B is X subsidiary. In turn, it is a subsidiary of A also, obviously. So what is the point here now that we need to understand? See the screen. Holding company, subsidiary, subsidiary. S1, S2, subsidiary, subsidiary. Okay, well, see. This company wanted to issue ESOP to the employees of A. Okay, this company wanted to issue its own employees. It wanted to give to the employees of B Limited. Permitted, like that can X Limited do? See. You can give, a company can give ESOPs to the directors, officers and employees of the company, holding company, subsidiary company. Associates not covered. Okay. Next one. What is ESOP? ESOP, it's an option given. It's a right given to subscribe to the shares in future at a predetermined price today itself. So future date la predetermined price you will buy. Means what? Even though the share price on that day is 1000, you will be having a right to buy the shares only at 500. Balance 500 is your benefit. Okay. Next, procedure for ESOP. In case of a public company, board of directors approval, shareholders by passing special resolution, comply with rule 11, rule 12. In case of listed company, follow also with the SEBI regulations. In case of private company, board of directors, board meeting approval. Next, shareholders ordinary resolution. Here shareholders special, here shareholders ordinary, comply with rule 12. That's it. Next one, segment 2 of section 62 also completed. Segment number 3, debt conversion. Which conversion? Yeah, debt conversion. Issue of convertible debentures or taken a convertible loan. Sir, this I will tell you in a simple format. Listen carefully. Okay, there is a company. That company has taken debt from government. Government will give loans, state development loans will be given. Government has given a loan. My company took the loan. Okay, in that loan agreement, nowhere it was written that conversion is possible. Okay, I made default in making the payment to the government. Government said that, okay, do one thing. I will convert this debt into equity shares. I will convert this debt into equity shares. Means what? You are not paying debt now. I can take action against you. Instead of taking action against you, I will become owner in your company. Government said that give shares to me, I will become the owner, such that it can become a government company also. Indirect plan. So what government can do, state government or central government, when they give loan, they will tell, I can take legal action against your company, but I don't want it to take that action. Whatever the volume of debt I have given, convert that into equity. Sir, at the time of issue of taking the loan, there is no terms and conditions like conversion. No problem. Government involved, all rules are broken. That's why what they said, Section 62 does not apply for conversion of debt into equity. Means what? Permissions are not required. Terms and conditions of such debentures provides an option to convert. Provides an option to convert. Sir, you said that it's not like that. Permission not. Adi this case, compulsory conversion by government. See, power vests with the state government or central government. State government or central government has given a loan to the company, and that particular company is not repaying the loan properly. Government, after considering financial position, interest rate, etc., want to convert. Such conversion may be made even if terms do not provide. Okay, normally terms are not there. Government is involved. Conversion can be made even without the terms and conditions. But other than government, you gave loan to say SBI. You took loan from SBI, or you took loan from some debenture holders. You are not paying them, then also you can convert that into equity. At that time, terms and conditions, it should be there, and obtain the approval of shareholders by passing a special resolution. Okay, va? Next, whenever you don't want government to go for conversion of debt into equity, in that case, company can make an appeal within 60 days. Okay, that's not a great point. In this, what is the most important thing? ESOPs. ESOPs, whenever you wanted to issue, ESOPs means an option given by the company to its directors, officers, employees of the company or holding company, subsidiary company, a right or a benefit to purchase the shares of a company at a future date at a predetermined price. Answer over. In case of public company, you need to take the approval of board of directors, shareholder special resolution, and rule 12. Listed company also SEBI. If it is unlisted company and it's a private company, board of directors at a board meeting, shareholders by passing ordinary resolution, rule 12. Okay, SEBI permission not required anyway because it's not a listed company. Debt conversion. Normal debt conversion from other than from the government require terms and conditions. If it is government, terms and conditions also not required. You can directly convert that debt into equity without complying with the section number 62 conditions. That's it. With this, we completed section number 62. I want a quick reply from all of you. Have you done a very much fast revision of section number 62? Everyone give a reply. Even at this time, even at this moment, if you are coming to live dilly-dallying it, generally coming for time pass sake, no one can save you. I'm telling you very, very clearly and seriously. Sit and complete. I clearly said share capital is a 10 marks area. Read this. 1 minute time for reading this. 1 minute time for reading this chart. Or 2 minutes I will give for this. 1 minute for this. Complete this in 2 minutes. Share capital chapter la benefit is questions are coming from the content directly. Create twist will not be there. So first complete this. Okay. You continue. Okay. Next. So enough time was given to you. I am not just referring to the answer. I am giving time for you to read because tomorrow exam. So we completed 62. Next one 63, 67, 68. 63 bonus. Yeah, bonus issue. See here, issue of bonus shares issued by company to the shareholders in proportion to the paid up capital, free of cost. That's called as a bonus shares. Conditions for issue of bonus shares. First one, authorized by AOA. First one, AOA should authorize bonus issue. Second one, the bonus shares is nothing but another way of giving the dividend. So therefore, what conditions are applicable for dividend? Ordinary resolution. This also require ordinary resolution. Next one, you are paying bonus issue means what? Extra profits are there. Therefore, no default should be there in payment of interest or principal on deposits or debt securities. Next one, statutory dues should not be there. It should be paid in lieu of dividend. Means what? Dividend declared, now it should be paid only in cash. Okay, you declared dividend and issuing bonus shares not allowed. You declared dividend. Okay, later you said, oh, profits are not there, therefore I will issue bonus shares. No, you stop giving dividend completely and issue bonus shares allowed. But bonus shares cannot be issued instead of dividends declared. Bonus issue can be made instead of declaring dividend. Bonus issue cannot be made instead of declared dividend. Okay, listen to my words, go back again. Next, partly paid shares must be first made fully paid. Okay, next one. If the decision of board of directors to issue bonus shares is not announced, it cannot be withdrawn later. So totally how many? 6. Authorization of AOA, shareholders ordinary resolution, no default in repayment of interest on deposits or principal on deposits or debt securities. Next one, no default in statutory dues towards the employees of the company, and bonus shares cannot be issued instead of declared dividend. It can be issued instead of declaring dividend. Next one, partly paid shares must be first made fully paid, and once decision is taken, it cannot be withdrawn. Sources from where you can issue bonus shares. Bonus shares can be issued out of 3 sources: free reserves, securities premium, and capital redemption reserve, but not capital reserve. Bonus shares cannot be issued by capitalizing reserves of revaluation of assets. Means what? Revaluation reserve cannot be used for issue of bonus shares. 1 minute time for you. Read this point clearly. One point I will add here. Listen carefully. Okay. Bonus shares will be issued in proportion. Will be issued in what? Will be issued in a proportion ratio. Means what? They will tell like this: 1:1 bonus. Company la authorized share capital is 1 lakh shares of 10 each, 10 lakhs. Okay. Issued, subscribed, called, and paid. Okay, issued, subscribed, called, and paid. Let us say 70,000 shares of 10 each, 10 lakh rupee. Okay, now how many are still there? 30. I want to go for 1:1 bonus shares. Okay, 1:1 bonus issue I wanted to go. Then what will happen? 70,000, another 70,000 I have to give. So it will become how many? 1,40,000 shares. But authorization is given only for 1 lakh. So you need to first alter the authorized share capital by altering the capital clause. That's why you can add another point here. If bonus shares results in change in authorized share capital, then section 13 alter MOA capital clause. Read with section number 61. Read with section number 61. Normally alteration of memorandum requires special resolution except section 61. If it is section 61, ordinary resolution is required. Okay, read this point clearly. They will ask in exam. You will be flying off if you don't listen properly. Unnecessarily you will only suffer. Please read that point also clearly. Okay, well, completed. Can I move on to the next one? Reply. Next one, 67. Mark this again, extremely important for the coming exams. Okay, 67. Very, very important for the exam. Let's see. What is section number 67? See, first one. Company has a restriction in purchasing or giving loans by the company for purchase of its own shares. Sir, buyback, na? This is not a buyback. Listen carefully. Just a minute. See here. What is section number 67? Restriction on purchasing or giving loans by the company to purchase its own shares. See here. Buyback means company voluntarily buying back its shares. Okay. Indirectly, what companies are doing, they are giving loan to the employees. Employees will purchase the shares of the company. And at the end, what is happening? Company funds are going out to purchase its own shares. Whether it is purchasing or others are purchasing, leave it away. Anyway, money is used to purchase its own shares. Correct? Allowed or not allowed is a question now. Okay, let's see. 67. Company limited by shares or guarantee having a share capital shall not buy its own shares except in case of reduction of share capital. Means what? If you wanted to take your shares, it should be only as per reduction of share capital. Reduction of share capital happens in two ways. Section 66, Section 68. Section 68 reduction happens along with the buyback. Section number 66 reduction happens only on reduction. Okay, so company limited by shares or guarantee having a share capital shall not buy its own shares except in case of reduction of share capital. Number one. Public company shall not give financial assistance, and loans, etc. to any person either by a loan, guarantee or security for purchase of shares of the company or its holding company. Okay, so a public company cannot give assistance, financial assistance to any person to purchase its own shares. Okay, it cannot give, but there is an exception for that. Exception number one. If the loan is given by a banking company in its ordinary course of business, for example, State Bank of India is giving share loans. Okay, security loans they will give and to purchase the securities in stock market for traders. They will give loan at a higher interest cost. Sorry, interest you keep away. They're giving loans. See, I took loan from SBI, purchased the shares of SBI. I took a personal loan from SBI, purchased the shares of SBI, and money belongs to SBI. Purchase whose shares? SBI. Why it is not prohibited? Because it's a banking company. Exception one. Okay, next. To the trustee for the purchase of fully paid shares of the company or holding company for the benefit of employees under a scheme approved by special resolution. Sir, what is this concept? The question will arise now. See here. Tata Trust will be a trustee. Author is Tata Iron and Steel Company Limited. For the Tata Trust is a trustee. Okay, Tata Trust will purchase the shares of all the big group companies of Tata Group. Simply, Tata Group, big companies are there, high share valued companies. Those shares Tata Trust will purchase. The trustee will purchase. So the trustee is purchasing the fully paid shares of the company or holding company. Either Tata Iron and Steel or holding company Tata Sons, it will purchase the shares. At the end, what is the benefit? When any employee is leaving the organization after 10 years, they will give the shares to them. So trustee is purchasing the shares of the company or holding company, not for normal purposes, for the benefit of employees. Allowed. Next one, very, very important exam question. This point. There can be a situation where a company can do lending of money to the employee of the company, okay, other than KMP, not exceeding their 6 months salary, to buy fully paid shares of company or its holding company and hold them as a beneficial owner. Simply, we are reading exceptions. Exceptions, what is the first exception? Banking company. Next one is a trustee holding. Third one is company can lend money to the employees other than KMP, but that loan should not exceed more than 6 months of the salary. For what purchase? For the purchase of the shares of its own company, they can give a loan, but that amount should not go beyond 6 months of his salary. Punishment for contravention, you can read here. Okay, this section shall not affect the right of company to redeem preference shares. Next one, this section shall not apply to Nidhi company if shares are purchased by company from a member on ceasing to be a depositor, etc. Simply it does not apply to Nidhi company. This section shall not apply to private company. Okay, shall not apply to private company. So a private company can give loans to its employees or loans to any person to purchase its own shares, no problem. Public company ke this problem will happen. Okay. Next, very important thing is private company. Will section 67 apply to it? Yes, it will not apply normally. It will not apply normally. So when it will apply, see here. This section do not apply to a private company. So private company can give loan to any person to purchase its own shares. Private limited company can do any of these three. Whatever it want, it can give financial assistance also to purchase its own shares, provided such a private company which is taking exemption or to take exemption from this section, that private company should be such kind of private company in whose share capital no other body corporate invested money. Means what? It is uninfluenced private company. Means it's not a subsidiary to company, it's not a what to say, holding company to any other company, like that it is not. It's a straightforward company. Next, borrowings, simply to tell, debt should not exceed twice the equity. Debt should not exceed twice the equity. And a debt equity ratio should be not more than 2:1. And a debt can be maximum 2 times of equity or 50 crores. Okay, or 50 crores. Okay. Next, either less than or equal to 50 crore. That is allowed to that extent, or twice the paid up share capital. Next, not defaulted in borrowing subsisting at the time of making the transaction. Okay. If these conditions are satisfied, yes, the company can go for giving the financial assistance or purchasing its own shares. Okay. So main point that you have to understand is a company limited by share capital or with the share capital and guarantee cannot purchase its own shares or cannot give any financial assistance to any employees, etc. For that exception is banking company. Number 2 is trustee. Number 3 is giving to employees, and loan tenure is not exceeding 6 months. Okay. Next, punishment, we already said that we have to read from there. And main important thing is this section shall not apply to a Nidhi company. Shall not apply to a Nidhi company. And it is not even applicable for private company, provided condition 1. It should be an uninfluenced private company. No other body corporate invested money. Debt equity ratio should not be more than 2:1 or 50 crores amount. Next one, no default, subsisting default in borrowings. If all these conditions are satisfied, a company can go for purchase of its own shares. That's it. Remaining content is not that much required for the exam. On par with the points given in the examination, we are discussing this. Up to here, please give a reading and complete. We'll go to the final section, section number 68. We continue. Next one. Yeah. This is relating to the most important section in this entire chapter, buyback. What is the concept here? Buyback. So buyback means power of company to purchase its own securities, section number 68. That easy section, just you need to remember the contents properly. Okay, nothing great in this section, but very, 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 very important for the examination. So please listen carefully. First one, buyback. Methods of buyback. Buyback may be made from existing shareholders or from open market, or you can also take back the ESOPs. So the mode of buyback means whenever you are buying back, from whom you will buy back? I will buy back either from the existing or from the open market directly, or I can buy as a ESOP. Number one. Number two, sources. What you will use, out of what you will buy, you have to buy now. From where you will buy? From normal bank account you will buy. Yes, from normal bank, but that money should come from where? Either free reserve, securities premium, or fresh issue. Okay, or fresh issue. Buyback cannot be made from proceeds of securities of same kind. Proceeds of securities of same kind. Wait a minute. Okay. Next. So buyback cannot be made out of proceeds of securities of same kind. Existing security holders you can buy, or from the open market you can buy, or from the securities issued to the employees in the form of ESOPs also you can buy. Okay, wow. Next, purchase should be made out of free reserve, securities premium, or proceeds of fresh issue. Buyback cannot be made out of issue of shares already issued. For example, I issued shares, two classes, par value 10, par value 7, issued already. Now that 10 rupee I wanted to take back. Now already existing 7 rupees enough. From that you cannot issue new and buyback, not the old one. Next one, buyback should be completed within 12 months of passing special resolution or board resolution. Sometimes special resolution is also required. Board resolution first. Sometimes yes are also required. Then 12 months start from yes are. Sometimes yes are not required. Only board resolution. Then 12 months start from board resolution date. Buyback should be completed. Once buyback is completed, all the physical shares should be extinguished within 7 days. This is the first part. Part 1 discussion over. Okay. Next part 2. Wait. Part 2 will start. What is part 2? Conditions. Okay. See, listen carefully. 1, 2, 3, 4, 5, 6, 7. 7 conditions are there. Okay. 7 conditions. Let us read. Point number 1. AOA authorization is must. Special resolution is passed. Just now I said, sometimes special resolution not required. When is that? Board resolution is sufficient if buyback do not exceed 10% of paid up equity capital in free reserves of the company. Equity capital. So it should not exceed 10% of the paid up equity capital and free reserves. In that case, special resolution not required. Board resolution is enough. Next one. Bought back shares should be fully paid up. Amount that is used to buy back does not exceed 25% of the paid up share capital in free reserves. So what is this point? Already 10% we said, 10% is a 10% of paid up equity share capital in free reserves. That is whether special resolution is required or not. Here that is not the point. Amount used for buyback does not exceed 25% of paid up share capital in free reserves. Simply to tell, special resolution ki 10% of paid up equity capital in free reserves. But here maximum buyback that you can go should not exceed 25% of paid up share capital plus free reserves. Next one. Sir, 1 year is there any limit for a year? This is overall limit. This is 1 year limit. In case of equity shares, okay, in case of equity shares, maximum 25% of the paid up equity capital can be bought in any financial year. So maximum how much equity share capital? 25% only. So I want all the students to read 3 points. We will make a comparison also now. Exam question, let's take some time also. 1, 2, 3. Read these 3 points first. Okay, so what is this 10%? This 10% is on equity capital, okay, and free reserves. This is for special resolution. And second one, this is overall limit on buyback. Overall limit on buyback cannot exceed 25% of paid up share capital and free reserves. In 1 year, maximum how much you can buy back? 25% of paid up equity capital, not free reserves. Because when you buy back in a year, you will buy back shares, not the reserves. So 25% of paid up equity capital only you can buy back. Next one, debt equity ratio after buyback. Listen to my words clearly. Debt equity ratio after buyback should not be more than twice the capital. Simply to tell, debt equity ratio post buyback should be not exceeding 2:1. Next one, buyback should be, if it is a listed company, buyback should be in compliance with SEBI guidelines or else rule 17. If you do any contravention, it is a punishment. Okay, see, 1 minute time I will give you. Please read this part of the chart. If you complete, please put me a message. We will continue with the remaining parts. Okay, next one. See, other conditions for buyback. Other conditions for what? Buyback. Whenever you are going for a buyback, okay, just wait a minute. whenever you are going for a buyback, it's a special business. Special business require explanatory statement. So notice of that particular meeting where special resolution is proposed shall contain explanatory statement containing the following: full and complete disclosure of material facts on buyback. What shares you are going to buy back, what is the buyback price, what is the current market price, all the details. So full complete disclosures, necessity, why you are going. Next one, which shares you are going, how much amount you are going to invest, and time limit for completion. Okay. Next, declaration of solvency. You should give a director should give a declaration of solvency. Okay, director should give declaration of solvency in form SH9. Okay, such a declaration shall be given that the company will not go for liquidation in the next coming 1 year time. Means what? Even after going for buyback, still we are having enough money. We are not going to liquidate. We are solvent. We are not insolvent. Okay, declaration should be signed by at least 2 directors. In that, one should be MD if it is there, if he is there. Procedure for buyback. Procedure for buyback. See, before buyback, company shall file letter of offer in form SH8 with the ROC. Such letter shall be dispatched to the security holders within 21 days of filing. Means what? Buyback cannot be made directly. Na? Buyback can be made out of existing shareholders. First point of what we read, buyback can be made out of existing. Existing shareholder, how you will buy directly? You will go and buy. Yeah? They have to give permission. Na? You should give an offer letter in SH8. File it with ROC. And it should be given to the security holders within 21 days of its filing. Next, offer will remain open for minimum 15 days, maximum 30 days. Next, if number of securities offered to security holders are more than those to be bought back, acceptance of shareholders shall be on a proportional basis. That's not that important. These are one important points that you need to understand. Up to here, you need to write the procedure. You need to remember the procedure. Okay. That's it. Most important contents in the particular buyback we have completed with this. Okay. Next, prohibition on buyback. Prohibition on buyback. When the buyback is prohibited, see, buyback you should make it directly, not through back door. So therefore, through subsidiary companies or through any other investment company, you cannot go for buyback. Sir, what is investment company, sir? Subsidiary means understood, you will ask subsidiary to invest. But what is investment company? I am X Limited. I will give money to HDFC Mutual Fund, and I will ask HDFC Mutual Fund to purchase shares of X Limited. Okay, HDFC asked, what is X Limited? X Limited said, my company only. Means through investment company you are buying, na, that is also not allowed. Next, there is a default during the last 3 years in repayment of deposits or interest, or a term loan from any financial institution, or redemption of debentures or preference shares, or payment of dividend. Simply, if there is any kind of financial default from the company, it cannot go for buyback for a period of 3 years from the default rectified, not from the end of the financial year, like DVR shares. If you rectify today, from here 3 years I will count. For 3 years you cannot go for buyback. After 3 years you can go for buyback. Next, filing default. If company has not complied with provisions of 192 annual report, 123 dividend, 127 failure to distribute dividend after declaration, 129 financial statements. If you are, you cannot go for buyback. Next, very important, after completion of buyback, company shall not make any further issue of same class of shares within 6 months. Then why you went for buyback? Okay, you cannot issue the same class of shares within 6 months time. And what should be the time gap between 2 buybacks? It should be 1 year. Okay. With this, we completed all the important contents in this particular chapter called as share capital. Which one? Share capital chapter. Now I will give time for the students to study for 15 minutes and complete it. After some time, I will again come for the part 3 of the marathon, wherein I will be completing another chapter like this, which is general meetings chapter, and also accounts of company. Very, very fast. First we will do accounts. Finally, I will also take I forgot to tell, I will be sharing the videos relating to 2 minutes discussions are there. Penalties, punishments, time limits under Companies Act, all these I will share in our Telegram group, also in WhatsApp group. Minimum 10 marks will come in the examination from time limits and penalties. So please don't neglect them. Listen to them also carefully. Okay. After some gap, again, I will come and do the revision for remaining chapters. Because this is a 10 marks chapter, I am doing the revision now. Okay. Finally, half an hour lecture I will upload directly, which contains 56 section to 59. Compulsory one question will come this time. That's why I will upload it directly. Listen, half an hour. Okay. So I will leave you now. 15 minutes time gap. Revise everything in the charts with regard to share capital chapter. Just to scribble the question bank. See what are all the questions that were there. 10 marks over. Go to the next chapter. Okay, na? And again, I will come back and I will take revision of accounts of company, another 10 marks area. Are you all clear, everyone? Continuously, you need not spend 3-4 hours time and waste your time. 2 hours completed, na? You spend 15 minutes to complete everything. Do other chapters, deposits, like that, small things. Again, I will come and I will give assistance for you in another 10 marks big area. Okay, I'm stopping the streaming, so you continue.